Good afternoon, everyone. I'm Diana with ASAP Accounting and Payroll, and I'm thrilled to have so many people on with us this afternoon. Before we kind of get started here, I'll go over a little bit of housekeeping. Hopefully we're all really familiar with Zoom by this point, but as it relates to today's webinar, I just want to go over a few expectations. We did collect a lot of questions prior to the webinar, and we will do our best to address those. We've got about 3 pages of questions, so we will do our best. Some of those questions will be answered throughout the presentation, so I do just ask for everyone to be a little bit patient. And for those of you who might be a little trigger happy and want to ask your question right away, I would ask that you actually hold on to your question and then ask it if we didn't get to it throughout the presentation. So also as it relates to Zoom and asking questions, we do ask that you use the Q&A feature and not the chat. So there should be a Q&A button on the bottom of your Zoom controls. Go ahead and use that to ask questions throughout the presentation. In the chat box, if you're not able to hear or you have some technical questions to ask, that might be the best place, but we're going to be monitoring the Q&A feature. As it does relate to sound, sometimes that has to do with the sound or volume on your actual computer. So try that first, and we will do our best to accommodate. This is a lot of information in a short amount of time. And so we just thank you for your participation and for your patience. We have a lot of attendees on here, and I'm really thrilled to begin today's topic. So before I kind of dive into introducing Michael, who's with us today, I do want to tell you a little bit about ASAP. And Michael, if you're there, I'll have you advance a slide for me. But I am the CEO of ASAP Accounting and Payroll, and we are a regional payroll processing and bookkeeping firm in Colorado. We have 3 offices, although we have clients all over the United States. And I like to say we're small but mighty. We are not HR professionals, we are not employment law attorneys, and so with a topic like this, we try to do our best to help our clients and be a resource, really for our clients and for our community. And so really that's what we're here for today. So I'll have you advance one more slide. I'm really excited to introduce Michael, and really what we'll cover today is Colorado's Healthy Families and Workplaces Act, regarding paid sick leave, as well as the public health emergency piece of that, and a bunch of Q&A to go along with that. As I've been saying lately, this is clear as mud. This is not something that's very black and white. There's a lot of gray. So hopefully Michael will shed some light on some of our frequently asked questions. And with that, I am super excited to introduce you to Michael Santo. He is partner and co-founder at Bechtel & Santo, an employment law firm out of Grand Junction, Colorado, and helps mutual clients for ASAP all across the state. And I've had the pleasure of working and presenting with Michael several times. So with that, I will actually go ahead and turn it over to you, Michael. And you might be muted still. Let's see. There we go.
Can you hear me now?
Yes.
Okay, good afternoon, everybody. We are today going to, the host has asked you to start your video. Start my video. Okay, and are we moving? Okay, so we are going to, good afternoon. We are going to spend most of the time talking about HFWA. Just let me get a couple logistics as Diana covered. It's not, I don't know why it's smudgy up here. Maybe I'm just out of focus. That's just the way I look. I don't know though. I've always wanted to do a talk where what we do is it's just nothing but Q&A, and I show up and I don't have any materials planned and I just talk, and then when it's done, it's done. And I thought, no, that would never work. I could never do something like that. This is how many questions we got for today's topic. So there's a bunch of questions. I will get to as many as I can as we go through and try to be very respectful of your time on the hour. I did want, of course, you may have heard there was some Supreme Court case last week, something about that. I put some background materials in here. You're going to see me go through them very quickly because it's not the topic for today, but I wanted to make sure this was available to you. What you do, what is CDC required for? Workplaces, do we have to wear a mask? What do we do if we need to let people know if there's if they had close contact? OSHA's got a helpful slide right here, and I know Diana and Tracy will get these materials out to you so you guys can have these. This came up last week, and the immunization requirements and all those things. The main thing I wanted to go over with respect to the court decision last week, for those who are wondering, it was not a decision on the case. It was a decision as to whether or not to grant an injunction, whether or not to stay. What happens when a lawsuit is filed is sometimes the defendant says, whoa, 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 don't let them do this because we're going to sue, and that lawsuit may take a while. So we want to stay everything. We want to hold everything in place before court you rule on whether or not this was lawful to do. Now, often it's a heads up to what the court's going to think, but it's not a guarantee. As you know, last week, the Supreme Court said that they were going to put an injunction in place with respect to the OSHA standards, but we're not going to put an injunction in place with respect to the CMS standards, which are up on the screen there for those of you covered by CMS. A couple things about that. One, this does not, here we go. They issued the injunction on the OSHA ETS. This decision does not mean you as private employers cannot require your employees to wear masks, does not mean you can't require your employees to be immunized, identify whether that they've been vaccinated, meet safety requirements, those kind of things. You can still do those if you want. This decision was, could the federal government require employers to do that? Private employers can still do that. So I had someone ask me last week, well, employers are telling us we don't have to wear masks anymore. And I said, frankly, you could have required employees to wear masks before COVID started. I'm not sure why you would, but you could have. So keep track in mind that for private employers, it just means you're not required to do things, but you still can. If you're covered by the CDPHE, you still need to meet. It does not mean, this is a double negative I just noticed, does not mean that you don't need to meet those requirements. So if you're covered by the CDPHE, you still have to comply with those requirements. That's the end of OSHA and immunization. Let's get right to it. HFWA stuff. Colorado paid leave. It came in, what I wanted to do from the beginning, and the questions really go into this, is it's a lot of questions like, well, I've got a PTO and I've got vacation and I've got sick and so how do those all work? As you're doing that, keep in mind that there are very distinct requirements under the law. And so the questions that often I think come up is, well, what are those? Well, there's HFWA sick, Colorado Healthy Families, and we'll get to in a second. But as we talk about it, there's a provision of the Healthy Families and Workplaces Act that discusses sick leave. It used to cover those with just 16 or more. It now, as of January 1, covers all of us. There's Colorado Public Health Emergency. What I often refer to save time, is HFWA-FEL. This covers all employers, and it has covered all employers since January 1, 2021. No, that's not a typo. Employers with under 16 employees, you have been required to comply with FEL, HFWA-FEL, for a little over 12 months now. You may not have been required to comply with HFWA sick, but you were definitely required to comply with HFWA-FEL. There's also FMLA, of course, and that covers just those with 50 or more. Then you got the ADA, Colorado Anti-Discrimination Act. There's an argument that there's an element of leave in each of those laws. Then we've got the Family First Coronavirus Response Act. This came out in April of 2020. It no longer is required. It was continued-ish in 2021 under the ARPA, and it provided certain tax benefits if you voluntarily complied. As I've been telling all organizations and talks, as you're working with your tax advisors, double check that you can take a benefit or take that deduction or whatever it's called under ARPA, because I struggle to say that Colorado employers voluntarily complied in 2021 because every single one of us was required to comply by the law. So we weren't voluntarily complying with the FFCRA. Just something to talk to your employers about. Those tax benefits ended on September 30th. To the extent that they existed for Colorado employers, they're gone. What else we got? We got Colorado Prop 118 leave, which is not applicable, which is the coming up 12 weeks of leave. That's coming up to start. We're going to start taking deductions in 2023. We're going to start providing 2024 those leave under that law, but that nothing to do with what we're going to be talking about today, and we have way too much to cover today to be talking about Prop 118. Then you've got the other voluntary leaves. You've got paid time off, PTO, vacation, bereavement, holidays, birthdays. Those, to some extent may be separate than HFWA, or they may be combined. But it's one of those things. I get a lot of questions like, well, what do we have to do under PTO for HFWA? First question I ask is, well, is your HFWA sick leave under your umbrella of PTO? Because some organizations still have vacation, HFWA sick, HFWA public emergency. Some organizations have PTO, which covers vacation and HFWA sick, but then public emergency. So it's always going to be different. So we'll work through some of that in those questions. There's a question. Yes, let's keep going. Okay. In June of 2020, the Colorado legislature passed HFWA. Why am I going back to last or 2 years ago? Because there was a question regarding providing HFWA fell or the 80 hours. In 2020, in June of 2020, Colorado legislature, much to their later realize of disappointment, passed the law that said, look, we're going to have HFWA start in 2021, but until HFWA starts in 2021, every Colorado employer has to comply with the Family First Coronavirus Response Act, the 80 hours. Even if you're too small, even if you're medical, you have to comply. So every Colorado employer was complying with FFCRA, even though you may have been exempted under the FFCRA in 2020. We've been complying with it since June of 2020. But of course, it did not continue FFCRA. It was just basically, hey, you have to comply with it. Then as of December 31st, 2020, all that went away. And we were left with HFWA sick, HFWA public emergency. Again, everybody had to comply with HFWA public emergency as of January 1, 2021. Everybody, only the larger employers, 16 or more, had to comply with HFWA sick at that time. What can an employee use HFWA sick for? These reasons. And it's basically employee's mental or physical illness, diagnosis, treatment, caring for a sick family member. Keep track that family member is very broad. It's those by blood, marriage, civil union, child. It's a person for whom the employee is responsible for providing care or arranging healthy and safety related care. One of your employees takes care of someone down the block, they get HFWA sick leave for that person. What is another reason to use HFWA sick? victim of domestic violence, harassment, sexual abuse, or a family member who's going through that. And when the public health official has ordered the closure of the place of business. Those are the reasons an employee can use HFWA sick. And again, we're distinguishing HFWA sick. What do you have to provide? Well, beginning on the day to hire, or if you hired them before January 1, 2021, that January 1, 2021, you have to provide all employees, and I mean all, part-time, full-time, PRN, casual, temporary, whatever they may be, if they work for you 1 hour a week just because they like the employee discount, they're accruing HFWA sick. So make a lot of questions said like, well, what about this exception? What about, it doesn't matter if you're a Colorado company and you got people working outside of Colorado, frankly, I'd be very expansive because the law is written very expansively, probably cover them. If you got a Colorado employee, but you're not a Colorado employer, I look to, to comply with the law so you don't have a litigation about 48 hours of leave, I would always encourage to take the state which is most beneficial to the employee. So if you're a Nebraska company, a Utah company, but you've got Colorado employees, my lean would be to cover them. It's one for every 30 hours worked, or you can simply front load. As we'll talk about, a lot more employers are front loading, and I think initially many people expected because of some information from the CDLE, that's Colorado Department of Labor and Employment, that has come out over the last year, makes front loading look a little easier. And we'll get into that in a second. Employees can roll over any unused paid sick time. And by this, I mean HFWA sick time. They can roll over anything, but you can limit it to 48 hours. So you can limit both the usage to 48 hours, you can limit accrual to 48 hours, and you can limit a cap of 48 hours. I'm not sure that's entirely provided in the law, but that's the approach CDLE is following, and it's beneficial to employers, so I'm all in. You can tell your employees, we cap you at 48. You cannot go above 48. Similarly, if you say to employees, well, we'll let you accrue up to whatever, but then we're taking you back to 48 at the end of the year. That's lawful. One question came up in the Q&As, well, can I just pay everybody and take them back to zero? Substantively, I think that meets the requirements of the law. I would be concerned procedurally because one of the reasons, of course, they put in this law was because a lot of employees, the legislature realized when COVID started happening, hey, these employees don't have sick leave and they may have spent their leave on other things. We need to guarantee that employees have sick leave so they can take time off. So is that substantively complying if you just pay them out from 48 down to zero? Sure it is, but I'd be worried taking anyone below 48 hours. So you can take them down to 48, you can cap them at 48 during the year. As I say here, employers can limit usage to 48 per year, and you can limit accrual at 48 in total. You got an employee who's got 46 hours, carries that over to the next year, they only accrue 2 hours in the next year. Now, if they use some, well, then now they can accrue more. But you say, yeah, but if they play it right, they can just keep accruing. Yes, but you can also cap them at a usage of 48 in the year for HFWA sick leave hours. So keep that in mind. So for example, I say here, let's ignore FEL for a second. Let's say hypothetical employee Bob accrues 48 hours of HFWA sick leave by September 2021. Great, he's done. We've capped him at 48. In late December, very late December, he uses 10 hours, which is what he ends the year with. How much sick leave does Bob carry over into 2022? 38 hours. How much leave can Bob accrue if he doesn't use any in 2022? if this employer has a cap, Bob can be stopped at 48 hours, so he would only accrue 10 hours. What if he uses some? As I said, then it drops down, then he can go back up to 40, down, back up to 40, keeping track that he's not required, or we're not able to, we don't have to allow Bob to use more than 48 in a year. Is there a maximum that Bob can accrue? Yes. Usage, total accrual, and accrual in the year can all be capped at 48. The division in discussions with them have clarified that they're getting the information from the statute, which says that up to an employee can be accrued in a year. They also say that, hey, this same information is provided in a different part, information 6B. So it'll be an interesting, and this is an esoteric question down the road, is that the law does say that, yes, they have to accrue 1 hour for every 30 hours worked. So, yeah, it's an interesting accrual. How do you accrue it, though? But in essence, DOL, Department of Labor, takes the approach. You can cap accrual at 48, you can cap usage at 48, you can cap total accrual at 48. All goes up to 48. You're not required to give any leave for HFWA sick. Hold on to that thought for HFWA public emergency. You're not required to give any leave beyond 48 in a year. How do we accrue it? Well, if you use the accrual system, it's 1 hour for every 30 hours worked. Do I have this in here? No, I don't. That is all hours worked. So if they got overtime hours, if they work 60 hours in a week, they accrue 2 hours. They got 45, they're 5 hours toward their next leave. So keep track for non-exempt employees, it's every hour worked, not every hour paid. So for example, they take a holiday on the Friday, then they get paid for 8 hours. They don't get to accrue HFWA sick leave based upon that hour paid. They only get to accrue based upon hours worked. Part-time employees, of course, people say, well, what do part-time employees accrue? 1 for every 30 hours. They'll, of course, take longer to get up to the 48, but overtime exempt employees, you can assume, those salary employees, you can assume that they're working 40, even if they're working 80 in a week. So you can say, hey, exempt employee, I'm going to accrue your HFWA sick leave as though you're working 40, even though you may be working 60. That is, permissible. By far, one of the biggest questions we get, or the most frequent questions, is, hey, I read an article, I saw something, I heard a bit in the seminar, that we don't have to do this. We're fine if we've got a PTO policy that meets the same thing. I would agree that there's been a lot of information out there on that. Keep in mind that if you're going to do that, it's got to meet everything. And I think when employers pose that question, they're often looking at, hey, it says 48 in a year. Our PTO policy gives more than 48. And so I'll ask them, well, do they start from the beginning? Do they start from the first day accruing? No, there's a 3-month waiting period. Okay, you don't comply with HFWA then, because HFWA you have to start accruing the first day. Do they get to carry over up to 48? No, we take them down, or, it has these rules. So if you want to call your PTO policy as, hey, I don't also have to give HFWA sick, remember it's got to meet every element of it, not just the accrual either. Like, for example, the law provides that if you, to have a compliant HFWA sick leave policy, you got to tell the employees, well, there's the thing, you got to tell the employees what the purpose for the leave is. And I know what you say, which is, well, if PTO says everything. Yeah, that may be good enough, and I'll argue that, God forbid, you get sued on this issue, but wouldn't it be easier if we just simply identified all the reasons in the PTO policy? If you're going to use PTO to cover for HFWA sick, I would definitely encourage you to put those reasons in that I had in that first couple slides. I mean, I go so far in our policies as to actually identify this policy is intended to comply with HFWA. I want to not literally beat people over the head, but I want to make it very clear we're complying with HFWA sick in this policy. You want to have the same annual accrual. You want to have the same notices, documentation. Two of the things I have never seen in a PTO policy or a vacation policy is an anti-retaliation and an anti-interference section. Who puts those in a vacation? But HFWA sick seems to state pretty clearly that those need to be in there. So before I say, yes, my PTO policy, this is my HFWA policy, I want to make sure I got an anti-retaliation provision in there. I want to make sure I have an anti-interference provision in there. I want to make sure I'm meeting every element of it. And so keep in mind that if you're going to claim your PTO policy meets HFWA sick, you want to meet it in full, not just a little bit. Employers can require that they use it in hourly increments. You can't require medical documentation. So for example, if your PTO policy says, hey, if you're out more than 3 days, we expect documentation, you're not complying with HFWA, because HFWA says you can't request that until 4 or more days. And frankly, even when it requested, it's pretty minimal what they provide. So it's not like they're even required to get a doctor's note for HFWA sick leave. So keep that in mind if you're going to try to claim all those are together. One of the biggest changes that happened at the end of last year, I thought was kind of quiet, was that the Colorado Department of Labor revised, more clearly stated, depending on how you want to argue it. Last year, there, of course, came out a Supreme Court decision that said you must pay vacation upon termination. You cannot take away vacation once it's earned. The Department of Labor clarified at the end of last year that it's not just vacation policies. It is, whoops, where did it go? Sorry, I'm on the wrong slide. There we go. It clarified that vacation leave, under that requirement to pay vacation leave, is pay regardless of its label that is usable at the employee's discretion, rather than leave usable upon the occurrence of a qualifying event. Like, hey, you can't take this till you got a medical issue. You can't take this till you got a holiday or bereavement. So if you've got a PTO policy that includes HFWA sick, don't forget that even though we don't need to pay out HFWA sick upon termination, you now need to pay out all PTO, which now includes HFWA sick. So if you say, well, we're a small employer, so what we're going to do is we're just going to have a PTO policy that's going to cover HFWA sick. We're not going to give any more rights for leave except that required by HFWA sick. But since it's a HFWA sick leave, we're going to say that we don't have to pay it out on termination. That can be tricky unless it's strictly a HFWA sick leave policy. If it's got an element of, hey, employee, you can use it for any reason, that may look like it needs to be paid out upon termination, even though it may principally be a HFWA sick leave. And that conditions thing, people may say, well, there's a 30-day requirement before you can use it as vacation. Yeah, that doesn't count as a procedural requirement. So they've clarified, the Department of Labor has, that this PTO is basically subject to payment upon termination, can't be taken away, even though it may include an element of HFWA sick, is the way to look at it. I've got some rules here. I didn't see any questions on it in terms of how you determine indeterminate shifts or on-call employees, but if you've got those questions, well, how do I figure out how much I should pay an on-call employee or someone with an indeterminate shift? Those are in your materials. As I say, we are not required to pay out unused accrued paid sick leave upon termination, paid HFWA sick leave upon termination, unless it's in the handbook or, frankly, unless it's covered by the PTO policy, and that's what we identified here. So be very careful of taking the approach my PTO policy doesn't need to be. If you want to have a separate vacation, a separate HFWA sick, no question, you don't need to pay out HFWA sick upon termination, or you can call it PTO, and then you've got HFWA sick. You would not need to pay out the HFWA sick, but you would need to pay out the PTO. So you want to be very clear with employees how that leave is working. Take a breath. Don't forget that if an employee, and there's a number of questions on this in these, if an employee separates and is rehired within 6 months after separation, you have to reinstate their accrued sick leave, HFWA sick leave, unless you paid it out upon separation. So if anyone comes back, you got seasonal employees, and they're not gone 6 months, that comes back to them when they come back. Okay, we're going to go through public health emergency, and then we're going to get to some questions. So you got your two leaves. You got HFWA sick leave, and then you got HFWA public emergency. They are somewhat combined. Let me get the question out of there. The first question, yes, we are still under a public health emergency. Someone said, well, you said that the other day that it's only through February. Yes, that was the other day. Now it's changed. January 14th, the federal Department of Human Services, Health and Human Services, came out and extended the COVID public emergency for another 3 months. So from January 20th, January 14th, through to February, to March, to April. We are under a public health emergency in the state of Colorado based upon a federal decision through April of 2022. Additionally, when the health emergency is over, you add a month to it. So if it does end, and here's hoping it does end April of 2022, employees can still use HFWA FEL for another month. Now, how many hours is it? Well, it's not 80, although frankly, and I'm as big a violator of this as anybody, we often refer to it as 80 hours, but it's really 2 weeks of leave determined by how many hours the employee normally misses, normally works. You got an employee who normally works 40 hours in a week, they get 80. You got an employee who normally works 30, they get 60. Part-time employee at 25, they get 50. So keep in mind, it's not everybody get an 80. So one of the this is something that came out in the rules, which is that even though you may not have been covered by HFWA sick leave last year, you were still covered by HFWA public emergency, and you're still covered. HFWA public emergency does not re-up. A lot of people say, oh my God, does that mean I had to give 80 hours in 2021 and 2022? No. If employee had not used any hours of HFWA public emergency in 2021, then their full bank carries over to 2022. But you don't, if they use it all, they're done. It's a one shot. There's an argument it's one shot entirely. I like the better argument of one shot of 80-hour allotment. But yeah, there is no, even if they keep kicking HFWA down the road, even if they keep kicking the public emergency down the road, it will still, it's just the allotment of 80. The Department of Labor clarified recently that even if Governor Polis comes out with a new order, like for Omicron or what's after Omicron, I don't know, that will not kick in a new 80. I was always concerned it would. It's not going to. It's an 80-hour allotment. As I say here, it's extended through April 2022, so we have dealing with this through at least May. So let's talk about what it means to give the 80, because this is something that was just recently clarified by the Department of Labor, is that the 80 we were all required to give January 1, 2021. But as the employee earns leave, it's the Department of Labor's approach that in essence eats into an employee's FEL leave. So if I'm an employee and I accrue 48 hours when I start on May 1st, 2021, let's say, even if, if I'm a larger employer, I got my 48, I only need to get 32 hours of HFWA FEL. If, on the other hand, we do an accrual and the employee accrues, 2 hours here, 3 hours there, now they're up to 5, now they're up to 6, that will slowly eat into their HFWA FEL, is the way the Department of Labor. So they're not looking at it as though it's 128 hours. They're looking at it as though, yes, we're under the 80. So if you give the 80, you can cap it at 48. So that's really only HFWA FEL that's the 32. I will say as a sidelight, I think that's an odd reading. I'm all for it because it helps employers. It's an odd reading, I think, a little bit of the Department of Labor, simply because, well, I mean, they interpret it, they look at these things all the time. But the reason I think it's interesting is because, of course, small employers weren't covered by HFWA sick leave in 2021, but we were by FEL, so we, small employers, had to give 80 hours. So now you got larger employers, well, they had to give sick leave in 2021, and they had to give FEL, but they still only had to give 80 hours, 48 hours of HFWA sick, then the 32 hours in total. So both small and large employers basically had to give 80 hours in 2021, although small employers only had to let employees use it if it was something covered by HFWA FEL. What is, well, here's HFWA FEL. Where is it? Yes. What is, am I in the right spot? Yes. When can you use HFWA FEL? You can use it for these issues: self-isolating due to a positive diagnosis, experiencing symptoms, seeking medical treatment for anything causing the public health emergency, suffering from a pre-existing condition where the public health officials have deemed it unsafe, if caring for a family member. The very odd literal reading of HFWA, not really addressed in the Department of Labor rules, but a very odd, very literal reading of it, is even if an employee tests negative for COVID, there's an argument that because the employee is experiencing symptoms of COVID, I got a headache, I got a stomach ache, that maybe they have access to FEL as well. I don't think, quite honestly, I don't think the legislature thought that we'd still be dealing with public health emergency under COVID in 2022. But that's the way it was written, which is that if an individual is suffering from symptoms of public health of COVID, they don't say you have to test positive for COVID. They don't say you have to be immunized as a condition of getting COVID. They simply say, if you're experiencing symptoms, you can use your FEL leave. If your employee is using, and this comes up a lot of times in the questions you guys submitted, if an employee is using the leave for something covered by FEL, it first comes out of FEL, then it can come out of sick leave, then it can come out of other leaves that you have available to the employee. So you first pull from FEL, then you pull from HFWA sick, then you pull from other vacation or whatever you may pull from. Keep that in mind. I see a lot of organizations pulling it from a PTO first or pulling it from vacation first. If it's covered by HFWA FEL, it has to first be pulled from HFWA FEL, cannot pull it from HFWA sick first. Now, if they blow out a knee, that's not covered by HFWA FEL, so they can pull it now first from HFWA sick. If you have it all under one big policy and you give the employee the 80 and the full thing under PTO, and they use it to go on a trip, and they use their 80, and they come back and they get COVID, do you then have to give 80 more? No. They burn the leave that you gave them under the PTO. Now, they'll still be accruing HFWA sick, so they'll still have that. But the HFWA FEL and the HFWA sick are all gone because you put it under one cap, one umbrella. And so if they use it for something besides sick, it's gone if you put it under that one cap. The one thing to keep in mind is if you put both leaves under one cap, don't forget you're paying that out upon termination because it is under one big umbrella. So that's the way very literally it reads. This is what I say here: usage order for leave covered by HFWA FEL. HFWA FEL, then HFWA sick, then other kinds of paid leave. Can we get documentation from an employee going out on HFWA FEL? No, not for purposes of HFWA FEL. You cannot ask for documentation. Now, the CDLE recently clarified, well, on the way back in, can I ask an employee to make sure they're not still positive for COVID? Yes. You can, if you can't condition it going out on leave, but you could condition it coming back from leave to make sure that the employee is no longer testing positive for COVID. So that's out there. That is a requirement. They're supposed to require soon as they know, carryover of leave. Don't forget, cap to carry over 48. You always have to cover, if you've got HFWA FEL in a separate policy, you always get to take HFWA FEL with you, although you can cut HFWA sick back to 48 if they're in separate policies. No paid leave is required if, I get this question a lot lately, my whole business is closed. Do I have to provide employees HFWA FEL or HFWA sick? If the whole business is closed, no. Now, what if you're a sandwich shop? What if you're a coffee shop? Well, we got 6 locations. I had to shut down one of them because they all had Omicron. Do I need to pay them? Well, you're not really entirely closed. So those who were missing due to symptoms of COVID, they would need to get paid because you got some divisions open, and you could, I think the law would envision you moving them over there. Now, what if you've got sandwich makers, or not just sandwich makers, their division's closed, but administration is still open? Yeah, I think that's a better argument that then you're completely closed. Of course, if an administrative employee got symptoms, then you would need to pay them. But I think then, like, if they're not scheduled to work, no one's scheduled to work who's a sandwich maker, I think there's a much better argument that that is completely closed. But no paid leave is required if the entire business is completely closed. You must put out the poster. I'd say you must have it in the handbook. You must have the policy in the handbook. I put a policy in the handbook. In fact, I put the poster in the handbook, and on the sign-off sheet, identify in the sign-off sheet, hey, attached to this handbook is the HFWA poster. So the employee is identifying, yep, I got the HFWA poster. You have to identify how much paid sick leave they have, how much they're entitled to, and don't forget, I don't want to end on this one, but there is individual liability under these laws. So something you always want to be careful of. Let's keep this one up as the last policy, and then we're going to get into the questions, which is start at HFWA sick. January 1, 2021, 16 or more, all others started January 1, 2022. They have to accrue 1 for every 30, or you have to give them 48 on a date certain. Every employee, there's no exceptions. First date of employment, they have to start accruing. You can cap leave used, you can cap maximum accrual, you can cap all that at 48. Then there's Colorado HFWA. HFWA we've all been under since January 1, 2021, and it provides employees 2 weeks of paid leave for a certain reason. Phew. I felt like I didn't take a breath the entire time there. Is anyone else tired? So just a couple of questions. And by a couple, I mean 1,000. Just want some clarification. Do all companies have to provide 80 hours from the first day of work? Yes. HFWA FEL starts on the first day of employment or January 1st, 2021, whichever is later. Took me a while to think of. Do full-time employees receive 80 hours immediately upon hire? Yes. They get it the moment that they start. What happens if it's exhausted? Then it's gone. You only have to give it the one time. How does a company work with an employee? Well, I was going to make a joke, but I'm not going to. How does a company work with an employee who've used up their 80? Well, they're still going to have HFWA sick leave available, presumably. Maybe they'll have HFWA, maybe they'll have other paid leave. Maybe they'll have other vacation leave. But once it's gone, it's gone. Do part-time employees qualify for FEL? Yes, they qualify to the extent that they're a full-time equivalent. So if they're a 0.5, they get 40. If they're a 0.3, they get, Diana can tell you what 0.3 times 80 is. I'm an attorney. I am under 15 employees, so HFWA just went into effect for me. HFWA sick just went into effect for you. HFWA public emergency has been in effect for you. Of course, within the first 48 hours of 22, I have 3 employees test positive for COVID. Oh, my goodness gracious. Of course, all 3 are in different pay structures and want me to explain the rules. Yeah. Each of them have HFWA FEL available to them. Doesn't matter how much their pay structure is, how much leave they have available to them depends on their normal schedule. So, did they carry over some? Did they use some in 2021? They may not have carried over 80. Whatever they carried over, they can still use. Do HIPAA hours reset for 2022? No, they do not. I mean, to some extent, yeah, you get to start accruing again, and your usage of no more than 48 gets to start again, but your bank stays as is. It carries over unless you're going to dial them back to 48. Colorado is not a use it or lose it state. Well, we're not anymore. We arguably were for a while, but we're certainly not now. But wanted to confirm that even though PSL were 48, even though PSL were, well, PSL, public sick leave, maybe public, I don't know, will roll over, we can cap at 48 use. I would be a little concerned about a PTO policy that dialed the employee back to 48 every year if that PTO includes, if you're saying, well, PTO is my HFWA, I would be a little concerned about dialing it back because don't forget, our general law right now says that PTO cannot be taken away once earned. And so, yes, HFWA allows you to, but that's only if it's a separate little policy. You may not be able to dial it back to 48 if it's combined with a vacation. The new rules, which are in the wage transparency rules, did not address HFWA. It simply addressed PTO policies, and it talked about sick leave in there, but it didn't say, like, here's how you deal with HFWA sick. So it is an interesting issue as to how that will work. Do you have to pay out all your PTO time? Yes. The way the new wage transparency rules read, you have to pay out all your PTO time upon termination, and no, you can't take it away at any time. Early adoptions of HFWA regulations provided an exemption to employers who already provided equivalent or more paid leave. Now, the earlies did, and they still do. Just make sure you're meeting all elements of that. Has this exemption extended to the current phase of the regulations? Yes, it is still there that you can have one policy. Don't forget, that policy comes with a lot of implications. If it's part of the PTO, can't be taken away, must be paid upon termination. If it's separate, you got some more discretion. Can this leave be considered part of their vacation, PTO? Yes, it can. And then they ask, or is it in addition to that? Yes, it can. You've got some discretion as to how you want to handle that as an employer. Man, I feel like I'm talking really quickly today. Just very excited about this. We have a current PTO policy that provides one bank of time for employees to use as vacation or sick leave. Okay, great, but make sure you're identifying it's HFWA sick, not just other kinds of sick. I mean, I would really be explicit about it. This may be surprising from an attorney. I don't like lawsuits. So I don't encourage organizations to have lawsuits that wind them up in a litigation debating about 48 hours. Make very clear with your employees. If you're going to say sick, you'll want to say it's HFWA sick and covered by that. Are we required to separate 48 hours to designate a sick leave? No, you can have it under one umbrella policy. And just make sure you're meeting all of those in there. What do we need to do to be sure we have in the employee handbook regarding PSL? I would state in there all the reasons they can use HFWA sick leave. I would state in there all the times they can use HFWA public emergency. I would identify how it's accrued. I would identify whether or not it's paid upon termination. Do you cap at 48 during the year, or do you roll it back to 48? I would also have an anti-interference and an anti-retaliation policy section in your HFWA sick and HFWA public emergency. I would make sure all of that's pretty clear. Does the employee forfeit their HFWA benefits if they are unwilling to provide any forms of documentation? No. In fact, the documentation requirement for HFWA sick is really low. We can't even make the employee go to the doctor. If the employee says, look, I got COVID, I took a home test, or I've got something, it's not COVID, I'm going to stay home and use my HFWA sick. Even if they're gone over 4 days, and the employee said, look, it was just a cold, I didn't go to a doctor. That's, in essence, could be sufficient documentation under the rules. If an employee goes home with COVID symptoms and they test and it is not COVID, can you require them to use their regular HFWA leave instead of FEL? Again, I read that statute very literally to say, and one of the last section I think it is, says missing for symptoms of the public health emergency. You could read that to say, yeah, if I wake up on Super Bowl Monday, which is the day after Super Bowl Sunday, with a headache because I celebrated a little too hard when the Tennessee Titans won, I just picked them, the Super Bowl, is that covered by FEL? There's an argument. It's a symptom of COVID. It's identified by the CDC that headaches are a symptom of COVID. You could have an argument that the employee gets to use FEL. Just wanted to confirm that the additional FEL hours ends on 2/13/2022. It did until 6 days ago. Now we've booted it down to May. Is this for part-time team members? Yes. Is this for temporary? Yes. Interns? If they're not an employee, no, but that would be an unpaid intern, and this is not the discussion for our volunteers or interns, really, volunteers or interns. This is a discussion about FEL. So if you've got, it doesn't matter what the title, if they're a paid employee, you need to give them HFWA paid leave. If they're a true volunteer or true intern, well, you don't really have to worry about it because we're not paying them for leave since they're not a true employee. Our tax credits for the employer paying out in the 80 hours, those ended September 30th. As I said, they may not have existed during 2021, but I'm going to leave that to Diana as to the tax advisors as to whether or not you can take that. But those tax credits are no longer, and they're completely separate than HFWA public health emergency leave. Because I had people tell me, oh, we're off because September 30th it ended. No, we're still under the health emergency, so we're still. I'm a bit confused as to why an employer must pay an undocumented COVID pay. Yeah, whew. And they say must pay an undocumented COVID pay, but yet receive no reimbursement. I guess I would say the reason why is because it's the law. There's not really a better reason for that than that. Let's see, are employers responsible to compensate for time off due to COVID symptoms prior to the passing of HFWA requirements? Yeah, that would be really before June, or is it July? July 16th of 2020 would be the only, and then if you're over a certain number of employees, not in the healthcare industry, you were covered by the FFCRA, the Family First Coronavirus Response Act. But don't forget, come January 1, 2021, we were all covered by HFWA FEL, so we have that requirement. I feel like I missed a page. Diana fell asleep. No, I'm kidding. Diana didn't fall asleep.
I'm like feverishly trying to answer the questions in the Q&A.
Any questions you want some help with?
Yeah, there's some
I want to be very, I was gonna say, I want to be very respectful of your time. Those of you who are saying, oh, I only had till 2, I think we're recording this, right, Diana?
we sure are.
So we're gonna go on for a little bit. You can always pick up the recording. It's available on the Diana's website, and just link away and watch it. But I want to make sure I get as many questions as possible.
Yeah, absolutely. I'll kind of just go, I'll just go through some here. Some of these were technically answered within the presentation. So to be respectful of time, you can rewatch the presentation and try to answer your question again. So don't be offended if I skip over you. We just need to be sensitive to time. And if I think it was covered, then I'll have you watch the recording for that. Let's see. There was a question in here regarding if an employee can pay out, like can front load some employees and then accrue for other employees.
Yeah, I mean, my initial response to that would be yes. Here's why I say that. I mean, you wouldn't want to say, hey, all the male employees are going to front load, all the female employers are going to accrue 1 for 30 or pick a protected classification. But for example, if you wanted to be a little more clear, like, hey, our exempt employees are going to accrue this way, our non-exempt employees are going to accrue that way, or field's going to accrue this way, and non-field. Yeah, that would almost be, in essence, lawful discrimination because it's based on a job classification, not a protected classification. So nothing jumps to mind that you couldn't have a couple of different accrual systems. That's HFWA sick. HFWA public emergency is a drop. So that you have to drop everybody in.
Okay, let's see here. I'm gonna go back up to a couple other ones. Are there any employers who are exempt?
The federal government.
Great. And then
so they're probably not listening.
Remote workers. So if they can work and can continue to work remotely, if they are taking care, that's one vein. The other vein is if they have a sick child at home and need to care for that sick child. Speak to that a little bit in terms of, again, an employee is an employee, whether they're remote or not, is my answer, but feel free to expand on that.
No, I mean, that's a great point. I mean, if they're working from home, then they're not really taking leave because they're working from home. So I mean, that is one of the problems with remote workers is, are they working from home or are they taking care of their kid most of the time? Or how much are they working? How much are they not working? I think if an employee's working from home, that's not leave. Leave means I'm not able to get to work. So it would be something you'd want to get clear with the employee going out. Now, if they're taking care of a sick kid, a lot of times it's, look, I'll get as much done as I can during the day, but it may be 2 hours someday and it may be 6 hours someday. Then we got to get into that question of, is it, what can you do? And do you just want to tell the employee, no, just go out and leave. Take care of your kid. Don't worry about work. You can do some things with that.
Kind of similar to that
yeah.
vein, if you've offered someone to work remotely, and send them home with equipment, whatever, but they don't want to, do you still have to pay out FEL?
If they meet any of the conditions for FEL coverage, yes. If they've got symptoms, if they've been quarantined, if they have, a positive diagnosis, if they don't want to work from home, they are covered by FEL. Now, if they're not, and they're just saying, I'm not working, I don't care if you give me all the equipment in the world, well, then they're really not home because of a public health emergency reason. They're just home because another reason.
Yeah.
And I couldn't even think of another reason because it seems like these days everyone is just home because of FEL.
Right. And then, this is a similar question, but it's framed a little bit differently. If somebody starts today and goes out for FEL tomorrow, you have to pay the full 80 hours.
Yeah. There's actually someone in Grand Junction, I won't use their name because of attorney-client privilege, but who I do know has been to two separate organizations within a month and gotten 80 hours from both of them.
Yeah.
So
that was, somebody else asked that one of like multiple employers and if they can get FEL from all the employers.
It's per employer, not per employee.
Right, exactly. Okay, a little bit different vein here. If an employer front loads PTO, does that have to be paid out upon termination?
PTO must be paid out upon termination based upon the new wage transparency rules. If there's an element of vacation to your PTO, that now needs to be paid out. There's no more use it or lose it. There's no more, we don't pay it upon termination. We took away that with vacation in the Clark's Market and Nieto case, and then the CDLE took that, I think, expanded out the term vacation because they were too worried that organizations would simply say, hey, we don't have a vacation. We have what we call Michael leave, and we don't pay out Michael leave upon termination. And so, by the way, I copyright anyone to use Michael leave in your handbook. That is something they wanted to address, and so that's why the wage transparency rules came in.
And there was a few questions in here regarding PTO, and for the purpose of today's conversation, there's a lot of best practices when it comes to PTO, and we're not necessarily covering all those today. So I did kind of dismiss those, and they're certainly, much more in depth than you get into that. And that's why at the end of the day, my recommendation is separate your policies, period. Just makes it easy on everybody.
I know Diana and I always have this come up at all of our talks. And I'm very respectful of what Diana says, so I'm not disagreeing. But what I would say, I certainly understand why the more regimented approach works, but sometimes for organizations it may not. Mm-hmm. So it is something, I think we both agree, Diana, in the end we want the client or the group, the company to, find the best policy for them. Mm-hmm. Sometimes, frankly, though, it's just easier to call it vacation, HFWA sick, HFWA public emergency. Leave it at that.
Yeah, for sure. This gets into a little bit of the what are you required to request in the way of documentation. And I know that we didn't necessarily go into that level of detail But one question is, we've been requiring employees to fill out a form to identify which of the reasons they're requesting for FEL, but we don't require a doctor's note. Previously, this was intended to provide substantiation for tax deductions under FFCRA. However, is this still an acceptable way to handle and document these leaves?
I think it is. I think it's definitely something you can do as an organization, because what you're trying to get the sense of when an employee says, hey, I'm missing, you got to figure out which bucket you're pulling from. And so is it FEL? Is it HFWA sick? You know, HFWA sick has a usage can't be used over 48. HFWA FEL has their 80. So even if they're combined, you need to know, am I pulling from HFWA sick or am I pulling from HFWA FEL? I need to figure out how much they're pulling from. I certainly think you can ask employees, you know, walk them through, is it covered by each of these things, to figure out which bucket you're pulling from, whether or not it's taxed or not. So you're not doing it for purposes of granting the leave, because you're just, you know, you tell the employee or the Department of Labor if they complain, hey, we gave them the leave, we just want to know where to pull from. Because you have this very regimented approach, Department of Labor. You recommended that we go FEL, then HFWA sick, then other stuff. So are we able to go to number 2? Or do we have to go? So I think that's fine.
Let's see, can you, and there might be a slide you just bring up as we answer the other questions, but related to the part-time employees and the reduction based on the number of hours worked, can you cover that again?
Under HFWA FEL or HFWA sick leave?
Both.
Yeah, part-time employees, the way the law, you know, what you want to do for FEL, or sick leave is really easy because it's just 1 for 30. Don't forget that, you know, if you say, hey, you know, I'm going to give you public health, I'm sorry, let's start all over. I'm going to give you sick leave employee, but hey, you're a part-time employee, so I'm only going to give you 24 hours. Keep in mind that to do that, if that employee then works over whatever pushes them 24 for the year, 30, Diana, whatever 30 times 24 is, that part-time employee needs to have accrued more. So for part-time employees, you know, keep in mind that 1 for 30 may work better because you're able to better determine how many hours they actually accrue. Because if you just give them 24, they may blow past the 24 in terms of how many hours they worked. So that could be a problem. You know, I have employers who will say, well, we give 5 a month to part-time, full-time, whomever, we give 5 a month. Yeah, what happens if someone, or 5 every 2 weeks? What happens if someone works beyond 150 hours? Nothing. It's 5 a month. Nope. Not under HFWA sick leave. That has to be at the rate of at least 1 for every 30. So if you've got an employee who works more than 150 hours in 2 weeks, they got to be accruing more than that 5. With respect to HFWA public emergency, I do have a slide, Diana, way at the beginning on that one, but it talks about how to determine that. So, and I know you'll be sending these out. Where'd it go? La, 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 la. There it is. Employees who work at the amount the employee is scheduled to work in a 14-day period, maximum, or the amount the employee actually works on average in a 14-day period, maximum. Of course, the problem with that is new employees don't know what it's going to be. So that makes it always tricky with part-time employees for HFWA FEL.
Couple questions along the line of like, should people have a separate policy for FEL? Or is it kind of ad lib based on the emergency declaration?
You want to jump into that, Diana, or you want me to? I mean, I think HFWA FEL, I really think if you want to combine HFWA sick, that's one thing with PTO. HFWA FEL is tricky for me because I wouldn't put it under the PTO umbrella, because don't forget, when this ends, and it's going to end next week, I think we're scheduled next week or the week after, I lose track, when COVID's going away. when that goes away, you can pull out public health emergency. So, I would agree with Diana. I like HFWA FEL being by itself. Maybe you still use the offset of the PTO, which has an element of HFWA sick, but that you're able to say this goes away when the public health emergency goes away. So I like HFWA FEL being by itself, even if you don't put HFWA sick by itself. This is where Diana says, but you should put HFWA sick by yourself.
All right, I'm just gonna go down these quickly. If we chose to do emergency paid sick leave through September 21 for employees and they got paid for COVID time off 2 weeks, are they still able to get FEL, or does the EPSL cover that?
I would say, in my opinion, and probably because I'm an employment attorney, not a tax attorney or an accountant, I would say that what you gave them was HFWA FEL. Whether or not it covered under EPSL, that is for your tax person to tell you whether or not it's covered under that. But I would say, no, what you gave them was HFWA FEL, because you're required under Colorado state law to give them that, whereas there was only the benefit of the federal one under that if you did it voluntarily. So I think my argument would initially be, yeah, that's HFWA FEL time.
Yeah, I would
Now,
agree with
maybe
that. I mean, if Colorado had a tax benefit, I would say you can't double dip unless it was, but that's not even available. So it's not necessarily worth hypothesizing over. Okay, CDLE Info 6C states that if an employee has not used FEL 80 hours in 2022, they can use the remainder when needed. For example, they use 60 hours, they'd still have $20 hours left. Question.
Yes. Yeah, you keep, oh, sorry.
Oh, no, go ahead. I was going to move on to the next.
FEL is yours until you're done with it.
Or until the public health emergency is over, correct?
Oh yeah, next week, yeah.
Yeah. If an employee works 30 hours per week and only uses 60 hours of FEL, do they still have a remaining 20 hours of FEL since they were paid their 2 weeks? We might have answered that.
I'm going to pull for those of you who are old enough to remember the old Saturday Night Live skit with Gerald Ford, which is, I was told there would be no math. So I'm sorry, can you go over that one again? I lost the number. The employee works 30 hours a week, so they accrue 1 hour a week. They use 16?
They use 60.
60. So if they, presumably they got to 60, and then they use 60. Now, of course, you wouldn't have to let them use 60. You can cap their usage at 48, even though their accrual may go up beyond 48. And you can cap their accrual at 48. So you wouldn't have to let them go to 60. And then it just, then they keep going back and accruing.
This one's come up a couple times. If we're supposed to use FEL first, what scenario would the general sick leave be deducted from FEL?
Outside of COVID? That came up at a talk recently where someone said, they asked me, like, what's the medical condition that's not a symptom of COVID? And I said, blowing my knee out skiing, or injuring my shoulder. But outside of any physical injury, if you read that very literally, symptom of COVID, I think you're always pulling from FEL first. It depends. Now, if you want to say no, if it has to be COVID, it can't be just symptom, then it may come to HFWA sick first. But if again, when you do that, read that part of the statute, and because it does say symptom of COVID. Yeah.
And there is no accrual for FEL. Like if employee, they can go into the negative. You give them 80 hours.
Yeah, there is no negative for HFWA FEL because it's a drop of 80 or 2 weeks, whatever it is, and then they're done. There ain't no negative because they're not earning it back. They don't accrue anymore. That's why I like HFWA by itself.
Yeah. Let's see here. So is there a list of health conditions that apply to the quote unquote increased susceptibility provision when an employee is unable to work because of a health condition that may increase susceptibility of risk of a communicable illness?
That is a great question. I have not seen that list. CDC publishes COVID symptoms list, but it doesn't. I have not seen what the increased susceptibility is. So that would be something that you could work with the employee's doctor to make sure, or just ask them, but I have not seen an exclusive list for what is increased susceptibility. It's one of those words as an attorney I had to learn. Anaphylactic reaction, susceptibility, and contraindicated. All the things I couldn't say before COVID.
Say that 10 times fast.
Exactly.
Let's see. Can we charge their use of FEL in any way against future accrual?
Not a FEL, because FEL doesn't future accrue. You could charge, you go have an employee, I guess, go into the negative on HFWA sick, because that does have a future accrual, but you should not, I wouldn't do that with HFWA FEL, because when it's gone, it's gone.
Right. This question's come up a few times. What if they live in a different state but work in Colorado?
Yeah, I'm really broad. I do not like lawsuits for 80 hours. So I would do what's best for the employee. So if they're working in Colorado, if it's less where they live. If you're in Colorado and they're working from remotely in New Mexico, boy, I would just want to make sure I'm not getting sued for 80 hours. Yeah,
and from an employment tax perspective, there's some things you need to consider there as well. So I'm not going to go into that, but I am the payroll person here, so I should stipulate that as well.
Oh my God. Remote work, Diana, I've got to increase your job on that like crazy.
Oh goodness, I won't even go into jokes there, but yes, if you hire a worker that lives in a different state, there are lots of different things you need to think about. Let's see here. Oh, some sample policies. Do you have sample policies, handbook language? How can you help people, Michael?
I can help people with sample policies and language and those kind of things. We put together I think in a 5-week span at the end of 2020, we put together something like 53 handbooks, which was just, all we were doing was handbooks. So we do handbooks like crazy. Do I have a sample policy that meets it all? The problem is, I think there's a lot of it depends. Do you want it to be an umbrella? Do you want to include vacation? Do you want HIPAA? And once you get into those, it's quick. It doesn't take long, but those are key things you want to make sure you're just not borrowing from your friend's policy.
H-2A workers, are they eligible for this as well?
I would think so. Yes, they're employees. You treat them as, I would treat anyone who I have on my payroll, who I'm paying, I would treat them as being eligible for this.
And along those lines,
that question though, but
we have restaurants that pay the tipped minimum wage and they accrue tips as part of their income. Can they pay out the sick as minimum wage?
They should pay out the sick as minimum wage. Don't use the tip credit for paying out the sick.
Oh, goodness.
I wouldn't, at least.
Does an employee have to specifically request FEL?
No. It's like FMLA. We are under an obligation as organizations to know if the employee, what leave they're going to need. If they just tell us, hey, I'm sick, it's our job to kind of come forward and say, give us some information. Keep in mind that there's that individual liability component to it. So, and you can't ding an employee for using FEL. So if you're like, oh, I terminated Bob because he was sick all the time, or he just kept missing and missing and missing, and Bob comes back and says, yeah, I missed because I had COVID, or I had COVID symptoms, and that should have been covered by FEL, and you ding me for something that should have been covered by protected leave. That could be a problem. So you'll want to make sure you know the reasons when an employee goes out. Make sure your supervisors, if you have an extended group or you have a large organization, that your supervisors are at least getting back that information to you, to HR, to the office manager, to someone. Like, I don't know why Bob is missing. He's just taken off. No, hold on a second. Let's figure out. Sorry to pick, for those of you named Bob, for some reason I always pick on Bob. You should pick on Michael.
There's a follow-up question on the using FEL before HFWA. I think there's still some confusion. If you can deduct HFWA general as part of FEL?
Well, I mean, if you have them as one policy, yes. Now remember, you can also have it as an offset. So you got the employee with 48 hours, they've got, and then you've got a separate policy, they only get 32. So you would draw from FEL for the 32, then you can draw from the 48. So, you know, that's oftentimes the benefit of having it separate, because you still get to use that offset when you look to see how much FEL leave they have.
Oh, that makes sense. They just keep coming in.
Yeah, no, I know.
And some of these get a little bit more complicated. Again, when you ask general PTO questions, there's a lot of it depends. But if we accrue sick leave now and pay out a percentage at retirement, I'm going to parenthesize that with separation of employment. Should or can we reduce that accrued amount, since we now have to additionally pay sick and FEL? I don't even know if I can.
We pay out, I mean, if it's, I would say, keep this in mind, if HFWA sick does not require it, you do not have to pay out upon termination. But if you have HFWA sick under a PTO policy, I would not recommend that you say, hey, 48 hours of that, as we identified, the first 48 is HFWA sick. So you had 80 or you had 120, you had whatever, we're going to pull out 48 hours. I get where you're coming from. I have told people my first Supreme Court case went to Supreme Court for $800 now there was other issues. And so they kept appealing and we had to keep responding, but blah, blah, blah. I would not risk it for 48 hours. So I would not pull out. If you have an umbrella policy, I think that we have limited arguments being very conservative to pull that out from that, from PTO, because look back at that wage transparency. If there's an element to it, an element to non-conditioned leave, it's theirs. We can't pull away. So
there's a couple questions
more,
regarding contractors, and this gets into our lovely muddy area of employee versus independent contractor. But in this case, they're a staffing company and have contractors in many different states, but they are on site at a company in a state, but on our payroll. Do they qualify for Colorado?
I mean, if you're pulling employment withholdings from them, I would treat them as an employee, and I would kind of, as I was just mentioning, the first Supreme Court case, that was on the independent contractor issue. I would treat them as employees if I'm taking withholdings. So I think that was the question.
And my answer is, with contractors, are you sure they're a contractor is my follow-up question. So I would recommend people look at those requirements first and foremost.
That is always a question.
This is a good question in terms of HFWA, and for small employers that don't meet the family medical leave, is paternity leave covered under the general HFWA?
Yeah, I mean, taking care of your spouse would be covered.
If an employee
So
chooses to
taking care of
stay,
your kid.
yeah, or there was
Sorry.
another one of taking care of someone with cancer, a mother with cancer or something, I would say yes.
Mhm.
If an employee chooses to stay home because someone else in the office had COVID, but they were not exposed, are we obligated to pay FEL?
My first question, now we get into do they have one of the issues where they have increased risk? If yes, then it may be FEL. If they don't have increased risk and they just don't want COVID, because nobody wants COVID, then they're not subject to that issue. They don't have COVID, they don't have any symptoms, and they don't have an increased likelihood of getting COVID because of their medical condition. Then I would say, yeah, I guess it wouldn't be covered by FEL. That's a lot of ifs to get to no.
Okay, well, I think I'm gonna, I know we do have a few other questions in here, but most of this was covered in the presentation, and I know that this is confusing. I am right here with you guys. And so I have had to rewind, reread, slow down, reread again, rinse and repeat over and over again. And I would just plug Michael here as a resource. And so use your resources.
Everyone's sitting there like, Michael's confusing. It's not me, folks. This law is just, I'm very empathetic to what our legislature was going through at the time. And you have to remember, it was the shortest legislative session, I think, ever. And certainly as far as I can remember, it was a really short session. They had these issues. I listened to a talk yesterday, which I was like, oh, how COVID affects business. This will be interesting. And as I started to listen to it, I realized it was someone who was speaking in March of 2020. And I listened to it just for nostalgia purposes, because they were like, oh, who knows how long this will last? A month, 3? We don't really know. And I was like, you're way wrong. So, I think I think the legislature put in some things with respect to HFWA that they just did not envision we would still be under this. I mean, one of the big issues that comes up is, what are we going to do with HFWA when Prop 118 leave starts coming in 2024? How do those work together? And it just was not envisioned that we would still be dealing with COVID. The law was, kind of look at it like the Fair Labor Standards Act, which came in 1939. And they're always like, well, how do you deal with at-home workers? Yeah, in 1939, we didn't have that. You left work, you didn't have a cell phone to track somebody down. So, yeah, it's a little wonky sometimes. I think the Department of Labor, quite honestly, is doing a great job of putting out information. If you aren't in touch with those interpretive notices, haven't had those, if you don't have those linked, get them linked. Our website, takes you to there, but you can certainly go to the CDLE. They've got some really good information. It's written as we're talking now. It's not to pick on the legislatures for how they write those things, but they still write them in all caps. Like, come on, let's go down to smaller letters. CDLE does a very nice job of walking through some of these questions.
Yeah, and I'm just impressed they continue to update the notices.
Constantly.
we don't get that from the federal level.
They're coming out all the time, and sometimes they change my advice, so I appreciate that. But try to agree with me more now.
Absolutely. Well, Michael has some great resources on HIP's website. ASAP has our help center. We'll also be sending out the recording and the slides from this webinar, and really appreciate everyone taking the time today. I don't know if this got any clearer, but lots of stuff to understand. And again, I think this is something you're just going to have to rewatch over and over.
Who wouldn't find that fascinating? Thank you, Diana.
Absolutely.
You guys
Thank you, Michael.
Amazing to work with. Thanks so much.
Have a good day, everyone.